People hear actual malice and think it means someone was nasty. In defamation law, actual malice does not mean hatred. It does not mean sarcasm. It does not mean they were rude, angry, biased, dramatic, or trying to hurt your feelings. Actual malice asks a much harder question. Did they know the statement was false? Did they publish it while seriously doubting whether it was true? Because in court, they were mean is not enough. The law does not ask whether the speaker had an attitude. It asks what the speaker knew about the truth, and that is where many defamation arguments fall apart.
Some legal phrases sound like they mean one thing, but in court mean something much narrower. Actual malice is one of those phrases. To a normal person, malice sounds like hatred. It sounds like spite. It sounds like revenge. It sounds like somebody wanted to hurt somebody else and enjoyed doing it. So, when people hear the phrase actual malice, they often assume the legal question is simple. Did the speaker hate the person? Were they angry? Were they trying to embarrass them? Were they being cruel? Were they acting like a villain in the comment section with a ring light and a Wi-Fi connection? That may be ugly behavior. It may be personal. It may be irresponsible. It may even be morally wrong. But in defamation law, that is not automatically actual malice. Actual malice is not about whether somebody was mean. It is not about whether they had bad manners. It is not about whether they disliked the person they were talking about. Actual malice asks a much sharper question. Did the person make the statement knowing it was false, or did the person make the statement with reckless disregard for whether it was false or not? That is the real issue. That difference matters because many defamation arguments sound powerful emotionally, but fall apart legally. Someone says, "They attacked me. They hate me. They wanted views. They embarrassed me. They were out to destroy my reputation." Those statements do not automatically answer the legal question. The legal question is not simply whether the speech was harsh. The legal question is what the speaker knew, doubted, ignored, or deliberately avoided when the statement was made. Starting with the definition, actual malice is a standard used in defamation law, especially when the person suing is a public official or public figure. The phrase became famous through the United States Supreme Court case New York Times Company v. Sullivan. The rule is this: a public official claiming defamation over statements about official conduct generally must prove that the false statement was made with knowledge that it was false, or with reckless disregard for whether it was false. That is the heart of actual malice. Notice what is missing from that definition. It does not say actual malice means the speaker was rude. It does not say actual malice means the speaker was sarcastic. It does not say actual malice means the speaker disliked the plaintiff. It does not say actual malice means the speaker was politically opposed to the plaintiff. It does not even say actual malice means the speaker was happy the plaintiff got hurt. The standard is about knowledge and reckless disregard. In plain English, did they know the statement was false? Or did they strongly suspect it was false and publish it anyway? That is very different from, they were nasty. And this is why the phrase actual malice is so easy to misunderstand. The word malice sounds emotional, but the legal doctrine is not mainly about emotion. It is about the speaker's relationship to the truth. A person can hate someone and still tell the truth. A person can dislike someone and still make a protected opinion. A person can be biased and still accurately report a fact. And a person can sound calm, polite, and professional while knowingly spreading a false statement. So the courtroom does not stop at tone. The courtroom asks for proof. Now let's talk about why this rule exists. The actual malice standard is tied to the First Amendment. Public debate is supposed to be wide open, especially when people are criticizing public officials, public figures, government conduct, public controversies, or matters of public concern. If a public official could win a defamation case every time someone made an honest mistake, public criticism would become dangerous. People would be afraid to criticize government. Journalists would be afraid to investigate. Citizens would be afraid to speak. Commentators would be afraid to question powerful people. Then public debate would shrink. So the law creates breathing room. That does not mean people have a license to lie. It does not mean falsehoods are good. It does not mean reputations do not matter. It means that, in certain cases, the Constitution requires more than showing the statement was false. The plaintiff may also have to show actual malice. That is the balance. The law protects space for mistakes in public debate, but it does not protect knowingly spreading defamatory falsehoods. That is the line. Now let's separate actual malice from ordinary negligence. Negligence is closer to, they should have known better. Actual malice is closer to, they probably did know better or strongly suspected it and published anyway. That is a much higher bar. Bad research is not automatically actual malice. A sloppy investigation is not automatically actual malice. Failure to call the plaintiff for comment is not automatically actual malice. Using a dramatic headline is not automatically actual malice. Getting a fact wrong is not automatically actual malice. Those things can matter in some cases. They may be pieces of a larger picture, but by themselves, they usually do not prove actual malice. The key question is whether the speaker actually knew the statement was false, or had serious doubts about whether it was true, and went forward anyway. This is where many online legal arguments collapse. People say, they did not investigate enough. Maybe not. But actual malice is not simply a bad journalism award. The law is not asking whether the reporting was perfect. The law is asking whether the speaker crossed into knowing falsehood or reckless disregard for truth. That is harder to prove, and it usually requires evidence. So what kind of evidence might matter? A direct admission could matter. If someone says in a message, "I know this is false, but publish it anyway," that is powerful evidence. Documents contradicting the statement before publication may matter. If the speaker had reliable records showing the claim was false and still made the claim as fact, that may support actual malice. Internal communications may matter. If people involved in the publication privately expressed serious doubts, but publicly presented the claim as certain, that may matter. A source problem may matter. If the speaker relied on a source they knew was unreliable, fabricated, or contradicted by known facts, that may matter. Deliberate avoidance may matter. If someone intentionally avoids obvious evidence because they do not want to know the truth before publishing, that can become important. Publishing after correction may matter. If a person is clearly shown that a factual claim is false, yet continues repeating it as fact, that may become relevant. Now let's look at what usually is not enough by itself.
I am Polamopicus, and this is Polamopicus Legal Concepts Explained for Non-Lawyers, by a non-lawyer for educational commentary, and is not legal advice.
Hostility is usually not enough. A defendant can dislike the plaintiff and still speak truthfully. Political opposition is usually not enough. Critics of politicians often oppose the politicians they criticize. Embarrassment is not enough. A statement can be embarrassing and still be true, opinion, privileged, or otherwise protected. Profit is not enough. The fact that someone made money from a video, article, live stream, or post does not automatically prove actual malice. A loud tone is not enough. The law does not become actual malice because somebody added dramatic music and a thumbnail with fire behind the courthouse. Bias is not enough by itself. Bias may explain why someone wanted to publish, but it does not automatically prove they knew the statement was false. This is important because online audiences often confuse motive with knowledge. They say, they wanted to hurt him, so that proves actual malice. No, it doesn't. It might help explain motive. But motive is not the same as knowledge of falsity. The question remains, did they know it was false? Did they have serious doubts? Did they recklessly disregard the truth? That is the fight. Another major confusion is the difference between falsity and actual malice. A statement can be false without being published with actual malice. That may sound strange, but it is essential. Falsity asks, was the statement wrong? Actual malice asks, what did the speaker know or seriously doubt when making the statement? Those are separate issues. Imagine someone repeats a false claim because they relied on what seemed to be a credible source. The statement may be false. The person harmed may be genuinely damaged. But if the speaker did not know it was false and did not act with reckless disregard, actual malice may be difficult to prove. Now imagine a different situation. Someone receives reliable documents showing a claim is false. They privately acknowledge the claim is probably false. Then they publish it anyway as if it is certain. That is a very different case. The statement is not only false. There may be evidence about the speaker's state of mind. That is where actual malice starts to come into focus. This is also why defamation cases involving public figures can be so difficult. It is not enough to say, that was false. It may not even be enough to say, that hurt my reputation. The plaintiff may need evidence showing knowledge of falsity or reckless disregard. And state of mind is not always easy to prove. People do not usually write, "Dear Diary, today I knowingly defamed someone." Although, given the internet, give it time. Instead, actual malice is often proven through circumstantial evidence. What did the person know? What sources did they have? What warnings did they receive? What facts did they ignore? What doubts did they express privately? What corrections were provided? What did they keep repeating? Did they present uncertainty as certainty? Did they leave out facts that made the accusation collapse? Did they deliberately avoid checking because the claim was too useful? Those are the kinds of questions that matter. Now let's apply this to online commentary. The internet treats outrage like evidence. The court does not. Online, people often say, they lied, they smeared her, they attacked him, they wanted clicks. They knew exactly what they were doing. Maybe they did, maybe they did not. But saying that is not the same as proving it. A court is going to ask for evidence, not vibes, not comment section confidence, not a 10-minute rant beginning with, "Everyone knows." Actual malice requires a legal showing and is usually more demanding than public outrage. This does not mean defamation claims are impossible. They are not. There are cases where people knowingly spread false claims. There are cases where defendants ignore obvious truth problems. There are cases where internal communications reveal serious doubts. There are cases where public statements are much more certain than the available evidence allowed. But the standard is high by design. So the lesson is this: actual malice is not a shortcut for hurt feelings. It is not the legal word for, "they were mean to me." It is not a punishment for bad attitude. It is a demanding standard focused on knowledge, serious doubt, and reckless disregard for truth. If someone says, they acted with actual malice, the next question should be, what evidence shows they knew it was false, or recklessly disregarded whether it was false? Not, were they rude? Not, did they hate the person? Not, did the audience get angry? Not, was the thumbnail obnoxious? The real question is knowledge and reckless disregard. So here's the takeaway. Actual malice is one of the most misunderstood phrases in defamation law. It sounds emotional, but it is evidentiary. It sounds like hatred, but it is about truth. It sounds like bad motive, but it requires proof of knowledge or reckless disregard. That distinction matters because a statement can be mean without being defamatory. A statement can be false without being made with actual malice. A speaker can be biased without knowingly lying. And a public figure can be harmed without automatically winning a defamation case. Actual malice is not the law asking whether the defendant was nice. It is the law asking whether the defendant knowingly or recklessly crossed the line from protected speech into defamatory falsehood. That is a much harder question. And in court, harder questions require evidence, not outrage, not assumptions. Not internet certainty. Evidence.
If you like this content, then kindly hit like, subscribe, and share. Caesar commands it.